I think that's our cue to get started, everybody. Welcome to Holland & Hart's webinar in relationship to COVID-19 antibody testing. My name is Christy Kimball. I'm a partner at our Salt Lake City office. I specialize in health law. And joining us after I give some information will be Mikel Jimenez, who is a labor and employment specialist. I think everybody, obviously, there's so much in the press about antibody testing to COVID-19, but there's been a lot of confusion related to this. And so the purpose for today's webinar is to really help people kind of understand the basics of antibody testing and to understand, what tests are currently authorized, what changes recently happened with the FDA in relationship to, the authorization of tests to be distributed and utilized in the United States. How can we utilize that information? What are the limitations? And then Mikel's really going to focus in on the labor and employment issues if you're going to be utilizing these within the workplace and how you need to, and the various laws that you need to navigate in that relationship moving forward. So with that, if we can move to the next slide, that would be great. I am going to start before I get into this slide. I do want to just give a little bit of an overview. I guess I have this assumption that most people understand what antibody testing is, but I think it's worthwhile to just give a little bit of an overview of that. So these antibody tests or serology tests, those can be used interchangeably. They detect the presence of antibodies in the blood when the body is responding to a specific infection like COVID-19. So in other words, the tests detect the body's immune response to the infection caused by the virus, of course, rather than detecting the virus itself. In the early days of an infection, when the body's immune response is still building, antibodies may not be detected. So that limits the test's effectiveness, and you have to make sure that that timing is so far out from when there's a suspected infection. So that's one thing that people should keep in mind. The performance of these tests is described by their sensitivity or their ability to identify those with antibodies to the specific coronavirus. So their ability to identify those with these antibodies to COVID-19, that's called the true positive rate, and their specificity or their ability to identify those without antibodies to this particular coronavirus is a true negative rate. A test specificity, it's estimated by testing large numbers of samples collected and frozen before coronavirus, is known to have circulated to demonstrate that the test does not produce positive results in response to the presence of other causes of a respiratory infection, such as other coronaviruses. These estimates of sensitivity and specificity are just that, they're estimates. And until we have, widespread testing of the public to really be able to kind of validate this, it's difficult. Tests are also described by their positive and negative predictive values, and that's called PPV and NPV. So if, later on we're going to talk about what tests are authorized for use within the United States right now, and if we're going to give you a link to the FDA's website where you can see what tests are actually authorized by the FDA right now, and you're going to see those terms PPV and NPV. And again, just keep in mind that that's referring to either the positive predictive value, which means calculating the sensitivity to somebody that is positive for having those antibodies, or the negative predictive value, meaning the ability of that test to identify that somebody has not been exposed. So that's what those terms mean, PPV and NPV. But every test, even those that are authorized, return some false positives and some false negatives. So everybody just needs to be keenly aware of that. But with that overview, let's talk about what happened. When COVID-19 hit, the FDA felt that it was more important to get available antibody testing on the market. And as they've done with many things, and many agencies have waived plenty of things, here they waived their normal processes for getting a medical device, a kit like this, a test approved. And one of the methodologies that they were utilizing under this emergency process was they really waived a lot of the normal requirements where for some manufacturers, they could just register that they were a manufacturer of these antibody tests, provide some information, and then because it hadn't gone through any kind of validation, any kind of process with the FDA, these suppliers had to warrant that they were going to include certain limiting information about their test kits, about their tests. So they had to have this information included so that the public knew that there were limitations to these tests. But what happened was that really led to hundreds of tests flooding the U.S. market. And then, as I think many of you may have seen in different newspaper articles, national newspaper articles, there have been some independent testing that's been done, several by universities, that showed that some of these tests that had been registered, with the FDA were wildly unreliable, with all sorts of, different test results coming out that weren't lining up at all. And you also saw that manufacturers were making inappropriate claims, not putting the FDA required disclaimers on these tests. But there has also been widespread outright fraud and criminal activity. There have been, fraudulent importing of supposed antibody tests coming in from China, from other places, where people have just been trying to import these, and these are tests that are not even registered with the FDA as being, an antibody test. And in some cases, these tests might just be purely fraudulent. They're not even actual tests. So because there was so much confusion, unreliability, and even, again, fraud and criminal activity, there have been charges brought against people for this. On May 4th, the FDA changed their guidance to address these problems. And if you've got the PowerPoint presentation, we've included the link so you can see the updated guidance. It was released on May 4th, and then it was updated again just this Monday. If we can go to the next slide. Luke, can you, okay. So here's an overview of the new process that the FDA has in place. Commercial manufacturers, they submit an emergency use authorization request with their validation data within 10 business days from the date they notify the FDA of their validation testing, or from the date of the policy, whichever is later. So now they've got to submit for these, again, for the FDA to give them this emergency use authorization. There are templates that the FDA has provided, and they're going to fill those out with their validation data, and then, the FDA is going to review that. The FDA has provided specific performance threshold recommendations for specificity and sensitivity for all serology test developers. So what we were just talking about, we were talking about specificity, on this exact strain, right? And then sensitivity, ensuring that it's picking up, the virus, and then it's sensitive enough to do that. The FDA has now given the specific performance threshold for these tests. And again, like I mentioned, there are now 2 voluntary emergency use authorization templates for antibody tests that have been made available by the FDA. One is for commercial manufacturers, and one is for CLIA-certified high-complexity labs that decide to seek FDA authorization. Luke, next slide. So which tests are authorized by the FDA? I would say if anybody's going to do these tests, and I've seen even on my social media feeds, just browsing the web, I've seen a lot of promotion of these antibody tests where people are trying to, make money by offering these antibody tests either to the public or to employers. And I think the most critical step you've got to make in this is make sure, if you're going to do one of these tests, that it is actually authorized by the FDA. Right now, there are only 12 antibody tests that are authorized by the FDA, but there are more than 200 going through this FDA process. So more and more of those will be hitting as being authorized under this emergency use authorization process. You can visit the FDA website below to review the FDA authorized antibody tests. And the FDA should be updating that on a regular basis to show you which tests are actually authorized. And when you look at that website as well, it goes in and it gives you an overview of the tests, you know, what the different meanings are of the various, you know, antibodies, because some of these tests, you know, test a little bit differently and will show you a little bit more information than others. So it's really good to go to the FDA website and get a good, you know, overview of this information. But then it has these tests, and it will show you their data in terms of what was submitted to the FDA, their validation data, in terms of their specificity and their sensitivity, so that you can see, you know, which ones. There's some that are going to be more accurate than others. There's some that provide a little bit more information. And so really review that website and review the tests to make sure that you're picking one that is as reliable as possible. But again, keep in mind, you're going to have some false positives, some false negatives with every single test. Next slide. So what are the limitations? And I guess I'm going to say there are a lot of limitations to antibody testing. There is still a measure of unreliability. Like I said, there are false negatives and false positives. There will be with every test. And again, while one may have the antibodies, this is something we really haven't discussed, but I think most people know, while one may have the antibodies as shown in the test, the amount of antibodies varies. And the tests generally don't measure the amount of the antibodies, just whether they're present or not. Some people may have been exposed, let's say, to you know, a low viral dose of COVID-19, and their immune system, you know, perhaps maybe, you know, fought it off, but they don't have a ton of those antibodies, right? They don't have a lot. So the amount of antibodies that somebody might have, even if they were exposed, the number of antibodies could vary from person to person, even if they have been exposed. But we still don't even know, even if you know, let's say that you have what we think are sufficient antibodies, it's unknown whether whether the antibodies will offer sufficient protection. For how long, you know, we don't know about that, or against all mutations of COVID-19. I think most people know that as COVID has spread across the world, there are these little mutations that keep occurring, right, genetically, where all of a sudden there'll be one small, you know, strand that's modified. And this is happening. We're able to look, as we look at the entire map of the world, and we're able to see where these mutations happened, and then see what strains, you know, are more prominent in certain areas. And so as the mutations occur, and again, there's just, you know, one mutation that happens at a time, but it's unknown if you were exposed to, you know, a strain that is since, you know, and then there's a mutation. Are you protected from that additional strain? And there's just a lot that's unknown about, even if you do test positive for these antibodies, again, do you have sufficient amounts? How long will that protection last? And will it offer protection as the COVID-19 virus mutates? Next slide. So the bottom line is there's still so much we don't know. And so I would say that you need to proceed with extreme caution. While I think getting tested, you know, it's certainly not a bad idea, but because of the room for error in these tests, and because we still don't know what protections will be provided by the antibodies, and we can't rely on current antibody testing with a significant measure of confidence, you just got to proceed with extreme caution and not take that result as the end-all be-all, and that if you are positive for those antibodies, that you're somehow, you know, 100% protected. For employers, I would make sure that if you are, you know, offering this testing, doing it for your employees, I would make sure not to make any kind of representations or warranties, you know, to your employees, to others regarding these tests and their meaning. And in fact, I would, you know, provide, you know, all these, you know, caveats and disclaimers about the test, so that you don't have anybody relying upon this as thinking that they're protected from COVID-19 infection. So how I think you can use this data, if you are going to use the antibody testing in any manner, is use it cautiously, but use the test results as one data point of many to make informed decisions for yourself or for others if you're an employer that wants to utilize the antibody testing. Next slide. So before I turn this over to Mikkel, the other thing I wanted to mention is insurance coverage. Medicare has said that for any tests that are authorized by the FDA under this emergency use authorization, that they will pay and they will cover for those antibody tests. And Medicaid will also be required to cover any lab tests, including in cases of self-collection. So that's and that's Medicare, sorry, and Medicaid will cover the tests that are authorized by the FDA. So keep that in mind, but in terms of private insurers, that's really going to be up to the private insurance carriers to determine whether or not they're going to cover this testing. So I just wanted to mention we'll carve out in relationship to insurance testing or insurance coverage. And with that, I will turn the time over to Mikkel.
Good afternoon. Thank you, Christy. That was very informative, and now I'm not sure what to make of antibody test results. But I can tell you that as an employer, there are a number of laws that come into play when an employer either requests some sort of testing or comes into information with those kinds of test results. And the four that I'm going to focus on today are the Americans with Disabilities Act, the Family and Medical Leave Act, the Genetic Information Non-Discrimination Act, and the Occupational Safety and Health Act, and then wanted to mention some new developments that are coming about with some of the states. So each of these federal laws, depending on what state you are operating in as an employer, you would want to see if there are more strict requirements in a state law equivalent. Many states do not have them and simply follow the federal rule, but certain states do. California immediately comes to mind. And the ADA is interesting because it impacts the relaxation of the medical screening prohibitions under the ADA have been relaxed during the COVID-19 pandemic, and it affects these other areas of the law. So we've provided a link to a Holland and Hart client alert that we put out that covers the relaxation of these different requirements. The two that are the most significant and that would implicate this antibody testing, well, one implicates the antibody testing, but you can take the body temperature and then the screening questions. So in terms of asking screening questions of your employees, perhaps we see this mostly when an employee is reporting at the beginning of a workday. You would ask about symptoms, you would ask if they've been tested, and that may elicit information about antibody testing. You are allowed to do that right now under the relaxed rules that have been issued. In a typical non-COVID-19 era, that would be considered a medical exam and is strictly prohibited unless you follow certain guidelines. So something to be aware of. You might also come into possession of this antibody testing information if an employee comes to you and asks for a reasonable accommodation under the ADA. They may come to you and say, for example, I took one of the antibody tests, so now they self-disclosed, and I tested positive for COVID-19. I've recovered. I went and had the antibody test, and it shows I have no antibodies. So now I feel that I'm more at risk for contracting COVID-19 again, and I would like you to make a reasonable accommodation for me to accomplish my job so that I can maybe continue to work remote or not interact with customers, or whatever the request may be. And so when you have that information from the employee, you may have to ask for additional certification from the healthcare provider to allow you to evaluate whether or not you can make that reasonable accommodation. And the big thing to remember when you are handling that information is that it needs to be treated with the utmost of confidentiality. So that information, including any test results that you obtain, would need to be kept in the separate medical file, separate from the personnel file for the individual or any other employment files that you keep. In addition to that, we must also, as employers, keep in mind that the Family Medical Leave Act still applies. In the old normal era, as I call it, we just had the regular old FMLA, which entitled eligible employees of a covered employer to take up to 12 weeks of unpaid job-protected leave for certain special family and medical reasons. And we're not going to dive into all of that today. But for purposes of antibody testing, employers under the FMLA are entitled to require that an employee provide certain things to establish eligibility for leave under the FMLA. So you can require a certification, medical opinions, and periodic recertification. That could include asking that employee to either go and take an antibody test or to provide you with the results of a test that they have received in support of their request for leave. So this version of the law still applies, and you would want to navigate it and keep that information also confidential. But we now have this new normal where we had Congress initiate emergency legislation under the FMLA called the Families First Coronavirus Response Act, the FFCRA. And again, that provides eligible leave to employees of covered employers with paid leave as opposed to unpaid leave for certain COVID-19 related occurrences. And that either occurs under the Emergency Paid Sick Leave Act or the Emergency Family Medical Leave Expansion Act. And the FFCRA incorporates the employer's ability to request the information that we just discussed, the certifications, the medical opinions, which would include that antibody testing. And under these relaxed rules, you can affirmatively, if an employee comes to you and indicates that they have COVID-19, you can make them self-quarantine for 14 days. You can make them certify that they're 3 days symptom-free without the help of, symptom-relieving medications. And that is probably going to lead into employees making disclosures or employers requesting these antibody tests. So you are allowed to ask for this information, but what that does is that gives rise to certain prohibitions in the next law that I'm going to talk about, which is GINA. That's the Genetic Information Non-Discrimination Act. So GINA is a discrimination law that applies to employers in 30,000-foot terms. It strictly prohibits the use in any of the terms and conditions of employment, from hiring to fringe benefits to termination. Any information that an employer receives about either that employee or the employee's family medical history. And that would, in fact, cover these kinds of COVID-19 related tests, the positive test, the antibody test, all of this testing. However, there are a few narrow exceptions. One of them is if the individual, if the employer receives the information pursuant to the FMLA. So again, if we're relying on one of the provisions of the Family Medical Leave Act or its emergency extension under the FFCRA, we would be within the ambit of GINA to obtain that information. But we have to be very, sorry, I'm not sure why the slides are advancing without me. I think my mouse is possessed today. In any event, back on the GINA slide. So if it's COVID related under GINA, it is not a violation to require body temperature, symptom screening, a negative test to return to work, and the healthcare provider certifications. But you have to be very careful about the way you store and use that information. Again, you would need to keep it in a separate medical file for that employee, separate from all of the other personnel files. You would also want to notify your TPA or your plan administrator that if they are gathering that information, it is not to be broadly disseminated. And you would want to consider creating, many of us have virtual filing cabinets out now. You would want to consider putting in place restrictions on those virtual filing cabinets or your paper filing cabinets so that managers or supervisors or individuals who are making compensation decisions, promotion decisions, and things like that would not have access to that information. One important exception to GINA is that you may also request a test if written informed consent is obtained. So in this era of antibody testing, which I think many employees are going to be interested in and many employers as well, so that you can evaluate the best way to create a safe workplace, you will need to and want to create a very robust, easy to understand consent form that explains the exact test that you're using, all of the risks that that Christy explained, again, making no promises, making no reassurances about the results or anything related to the test, and having the individual employees sign that written consent so that you are coming into the safe harbor of GINA. So if you've done that and obtained that written consent, then you would want to keep that in the file with that antibody test that you have requested from the individual. A couple of other things to keep in mind so that you maintain compliance with GINA is records. All forms and data must be maintained in separate files from personnel files. You can store them with other medical files. You treat them as confidential medical records. So if you already have your ADA compliance protocols in place, that's going to satisfy GINA compliance as well. And then remembering there are some very, very limited circumstances where you may have to disclose that testing information, and I've listed those. Employee remedies and enforcement under GINA, not necessarily anything to be scared of, but just remembering this is a discrimination employment law. If an employee feels like the testing information has been used in a discriminatory way, they can file a charge of discrimination with the Equal Employment Opportunity Commission. They can make hostile work environment claims if the test results were leaked and individuals were making slurs, other employees were making slurs or creating some other form of hostile work environment. And this could lead to retaliation claims if the employee believes that a manager or a supervisor or somebody has taken an adverse employment action against them, demoted them, docked their pay, denied them a promotion, denied them a position for which they had applied based on the test results. So again, another reason to make sure that we keep the information separate, we keep it confidential, and we limit access to the information. So another law to keep in mind, again, we're not going to dive into this too deep today, is the Occupational Safety and Health Act. Because under the General Duties Clause, we are, pardon me, let me get back there. Under the General Duties Clause, we are required as employers to provide a safe workplace. You may have some employees who ask about this antibody testing as one of the measures that an employer takes to keep a safe workplace. You may also use the antibody testing as a way to decide where you're going to, what kinds of measures you're going to implement, what kinds of social distancing measures, what kinds of PPE you're going to use, and things like that. And you would want to consult with OSHA and those guidelines. Recently, also, some states have responded to employer cries for immunity from liability related to COVID-19, and you would want to check the state where you do business to see if your legislature has enacted any civil legal immunity statutes. For example, in Utah, we had our legislature held a special session, and during that special session, they passed a new law that provides civil immunity for employers. And they took a very broad view in defining what a person is. So it's this whole list here, everything from individuals and associations to governmental entities. And they've also decided that they're going to apply it broadly as to workspace. So it's real property or any appurtenant building or structure. That law in Utah went into effect on May 4th. And what that means, and go back for a moment, they have carved out a few exemptions from liability immunity. It does not extend to willful misconduct, reckless infliction of harm, or intentional infliction of harm. But what that does mean is that if an individual is exposed to or contracts COVID-19 on the premises of one of these persons, as they have defined it, there would not be a civil cause of action against that entity. So how does this all come together? If you are considering as an employer using the antibody testing, first and foremost, you will want to have a consent form, and it needs to be informed consent, which I know as healthcare entities, you're very familiar with what informed consent means. It must be in writing. It should be limited as to the scope of its use for the antibody testing and who gets to use it, and it should limit access within the organization. So some employers may want to use this to evaluate high risk versus low risk, different kinds of positions. You would want to be very careful in doing that because, again, harkening back to GINA, the Genetic Information Non-Discrimination Act that we discussed, if you use this information in a way that, let's say some employers are now offering premium pay, or some call it hero pay, for individual employees who are either working on the front lines in the healthcare field or in other fields are in positions where they have more interaction with customers or clients or patients, so it could be deemed more high risk. So some employers, in recognition of that, are offering this premium pay or hero pay so that they can acknowledge the individuals who are working in these positions. However, if you use this antibody testing as a way to decide who you are going to put into one of those positions or offer one of those positions to, and excluded those who didn't have it, you may have an issue where you have an employee who says, hey, I didn't have the antibodies present in the test that I consented to in writing, but I'm still willing to assume that risk. And you didn't even give me the opportunity. So you've now discriminated against me in the terms and conditions of my employment because you didn't give me this job opportunity that I was otherwise qualified for. So something to think about as we try to navigate this very unknown and rapidly developing area. It would be helpful and considered best practices to create objective criteria for how you're going to use information to place individuals in high versus low risk positions, to offer them to everyone, knowing that if somebody doesn't have antibodies or they have other issues that may make them more vulnerable, you would want to consider the kinds of informed information and assumption of the risk information you would want to give them. We've talked about compensation considerations and developing that objective matrix. We'll open it up for questions, but a couple of really good resources because all of the information that we receive is changing sometimes by the hour. Holland & Hart has a COVID-19 resources for healthcare industry, and if you click on the link on the slide, it'll take you there. And we also have a Holland & Hart coronavirus resource site that provides information more broadly on real estate issues, on insurance issues, benefits issues, workplace safety issues. We have OSHA and checklists. We have a more in-depth discussion of the FFCRA and the different kinds of paid sick leave and the requirements and eligibility for that. So that's a valuable resource as well. And with that, I would like to open it up to any questions. I don't see questions in the Q&A, and Christy, I'm not sure how we decided we were going to take questions for this webinar.
That's a great question. I guess I need to look and see. We didn't talk about that beforehand. I don't see any questions that have been asked to the right. Do you, Nicole?
Oh, I see one question. Here's one question, two questions that have popped up now. So first question, my company, which is a healthcare employer, wants to require employees to report positive COVID tests, not antibody, to employee health so we can track workplace exposures and do contract tracing if needed and connect them to HR for reasonable accommodation. So I'm assuming you're asking if that's okay. At this time, yes, it is okay to ask as a part of your screening questionnaire if an individual has tested positive for COVID-19. Christy, is there anything you would want to add in answer to that question?
No, I think most healthcare providers, where they have the testing capabilities, I think that they are engaged in that, and I think it's important. So I think that is going on, and I haven't had, specific concerns about it. I think that certainly there could be employees that, raise a concern and don't want to be tested for whatever reason, but I think that's going to be governed by that workplace. And I think that in order to try and prevent the spread of COVID-19, if there are, you want to make sure that as much as you can control it, that you're having healthcare staff that are not potentially exposing patients or other healthcare staff. So I think there are, a lot of measures going on to try and test and utilize that information. So, but I guess I would defer to you, Mikkel, on the labor and employment side, what the limitations are and as far as how they can utilize that information.
And that's what I was going to add is that the reason that we can, as employers right now, ask for whether or not someone has tested positive for COVID-19 is, and the reason the EEOC relaxed the standard for medical exams that are prohibited under the ADA is because there is an existing exemption when something poses a direct threat to the workplace. And so because COVID-19, as it's declared a pandemic, is a direct threat, we are allowed to ask for that as a part of the screening process. I would just reiterate that when you are developing the procedures that you want to put in place within your organization to take that information in, if you're going to take it in at the beginning of the workday through a screening process, that screening process should be separate and confidential. So you don't want to have your screening individual asking the employee if they've tested positive for COVID-19 within earshot of, the 6 other employees that are standing 6 feet apart from each other behind that employee waiting for their screening test. You'd want to do that privately. In addition to that, you indicate in this question that you want to connect that individual to HR for reasonable accommodation. I think that is a very good forward-thinking idea, and you want to make sure that you've coordinated with HR for the protocols that they are going to use once they receive that information from the screener about putting that in the separate medical file and limiting access to that information. There's another question here that is, some are talking about immunity cards. Is this related to antibody testing? And Christy, I think that is a question for you. I am not aware of whether or not of what that is.
Okay, I'm so sorry. Say that again, because for whatever reason, I think it's because we have an issue with me being listed in the system as a presenter. It's not showing me the questions.
So the question is, some are talking about immunity cards. Is this related to antibody testing?
Well, it would be. I think that there are, potentially that they've looked at. I think there might be different countries that are looking at doing that, but I don't think that you're going to see that. I think that that's kind of more, like speculation, and it seems a little fantastical. I think that's kind of more out of fear, like, oh, I have an immunity card, I'm good. I don't think you're ever going to see the United States government nor a state government issue any kind of cards like that, because we don't have enough information to know if somebody's immune, number one, nor, what would be the purpose for that. So I think that's kind of more a little bit of kind of fear-based, but I don't think you're going to see that happening.
I also, if I were an employer or if I were advising one of my employer clients, I would not recommend that employers even take these cards because, again, you are now in possession of genetic information that, if used inappropriately, could lead to a discrimination claim under GINA. The next question is this. My workplace is considering an opt-in event with an organization who is hiring the healthcare providers to draw the test and communicate directly with the associates. No information would come to the employer. Concerns if we run this like a flu shot clinic. So Christy, what are your thoughts on that? Oh, we may have lost her. I think that is an interesting, I think that is very interesting. I think I'm assuming that the employer is going to pay for the test, and I guess, you know, then if you're leaving it up to the associate to let the employer know, it would be okay. You would definitely want to have the appropriate documents in your appropriate language in your agreements with the healthcare provider, the third-party healthcare provider, that they did not share the information with the employer. They didn't communicate that to the employer in any way. But my guess is that you would, out of that, have some employees that would come to the employer and ask for accommodations or other workplace accommodations or advancements or whatever, you know, maybe they want to apply for a high-risk position if they find out they have antibodies, and then you'll have to make sure you're properly dealing with the receipt of that information. The next question is this. We have implemented temperature checks and symptom questions before allowing employees back in the corporate office. Should we require antibody testing for our traveling salespersons in lieu of the temperature check? And I'll let Christy weigh in on this as well, but my recommendation would be that you not have antibody testing in lieu of the temperature check. The temperature check is much more, and this is my opinion, it's much more reliable, if you will, than the antibody test. The CDC has come out with guidelines that indicate if an individual has a fever of 100.4 or greater, that is a strong indicator and symptom related to COVID-19. Not having a fever does not mean you are COVID-19 free, as we now know that there are people walking around who are asymptomatic. But that is a more reliable indicator of symptoms. The antibody testing, as we've heard from Christy today, and why I started with, you know, now I don't know what to make of the antibody testing, is there are false negatives, there are false positives, there are some tests that are more reliable than others, and so there would be a lot of uncertainty, I think, on the employer end if you were really relying just on the antibody test. Traveling, I think best practices still would indicate that when someone's traveling for work or traveling at all, that they need to self-isolate for 14 days upon return home before they come back to the corporate office. And I think you keep your screening system in place where you do the temperature checks and you ask the questions, and you may add the antibody test to that, but I wouldn't throw the body temperature test out the window in lieu of it. Next question, how can we protect our associates who are administering the temperature checks? Masks and gloves, more OSHA training required for that PPE. Sorry, not an antibody question. That's okay. That's a very good question. And I think it's a hard one to answer because you can't just hop online anymore or run down to your local, you know, Home Depot or Harbor Freight or whatever, you know, medical supply store and buy a bunch of masks and gloves. They're in some cases more in demand than toilet paper. So the way that you can protect your associates is to make sure that the person who's administering the screening, if you can get the laser body temperature test so they don't even have to come into contact with the employee, they can maintain their social distance. You would definitely want them to have a mask on. You may want to consider having them wear glasses because, of course, the big thing is not touching our mouth, our nose, and our eyes related to COVID-19. And having them wear gloves, and perhaps some kind of a protective gown. But that's if that is available. You can look on OSHA's website, and they have some guidance that they do not have specific PPE requirements related to this kind of screening. It's just not possible right now. The next question is this. If a facility utilizes a self-assessment of symptoms and temperature check and documentation upon entry into the facility, should this document of names and temperatures be considered confidential? And the answer is yes, even if it is self-identifying or you're filling it out on your own. And I know that some employers right now, the employee fills it out either on an app or through an email or something before they come into the office. That information all has to be treated as confidential medical information and has to be stored separately in that employee's medical file. So very separate from the personnel file, very separate from where we would see things like their performance evaluation or their application for employment or any of that information. So whether or not it's obtained by someone else in the screening process or it's a self-disclosure, you want to treat it still as that separate medical, confidential medical information. I think those are all of the questions. If anybody else has a question, yes.
There's a couple of questions that came into the chat. Should I relay those to you?
Yes, please. Let me know the first one.
Okay. The first one is there any place for antibody testing as a gating item for determining who comes back to the office out of the general workforce?
So I am not aware, and my guess is Christy is, but I think we may have lost her connection.
No, I'm here.
I'm here. Okay, good. Christy, are you aware? I'm not aware of that.
Yeah, well, last week we talked about this a little bit, right? So there was, I think every employer needs to look at this. So was it OSHA or the CDC who put out the thing talking about high risk, high risk people, low risk in terms of employees and do you know what I'm talking about, Mikkel?
Yeah, I thought, Luke, did I misunderstand your question? I thought your question was whether or not we know of specific antibody testing facilities.
Yeah, well, the question was, is there any place for antibody testing as a gating item for determining who comes back to the office out of the general workforce?
Yeah, and I think you can include that in your screening, but I'm not aware of a specific company or facility that's doing that.
No, but you can go to the FDA website because we've given you the information about what tests are authorized. And I do think that ARUP here in Utah is doing antibody testing. I'm almost sure that they are. But you could contact them and ask them if they're doing antibody testing. But I believe that I read that in the Salt Lake Tribune a couple of weeks ago, that they've got one of these tests up and running. And then I think technically in Utah, you don't need a physician order. I don't know where this, person is from. In Utah, you don't need technically a physician order to get laboratory testing. So you could contact ARUP here in Utah, if this question is coming from Utah, ask them if they're doing antibody testing, and then ask them what the protocol is for coming in to get that testing. So that's the first thing, and you could do that in any of your states, right? But go to the FDA website, look at the approved, and then you could start calling some of your local laboratories to see if they are conducting any of those antibody testing, and then the process for getting in and getting tested. In terms of utilizing that as some kind of, gating method for getting employees back to work, like I mentioned before, that should be one of many factors. And if you go to last week's webinar, I don't know, I think those are those, I'm not sure where those are posted, but I think those are posted on our website under our healthcare area. But we did give you, links. I think it was OSHA came out about a week ago, or it might have been the EEOC. Anyway, because it kind of wasn't in my ballpark as a healthcare attorney. But they did go through and discuss high risk, individuals for COVID. Right, so those are older patients, patients with underlying heart disease, high blood pressure is a big risk factor for COVID-19 complications. It goes through some of those risk factors, and you should look at that. But that documentation that I think came from OSHA talked about making sure that patients that are high risk for COVID-19 complications, that where possible, putting them in lower risk. If you can accommodate that back into lower risk areas of the workforce. So I think I mentioned this in relationship to healthcare providers. If you've got someone that has these that are high risk patients, or high risk individuals, or they've got a member of their immediate family that's high risk. You want to identify that, and then if possible, let's say in a physician office, if that person can work in a way that's not patient facing, where they are not interacting with the patient, that's what I would do. If you can get the social distancing measures in place in that office where, they're working alone, having very little interaction, that's great. If they can work from home, even better. So you want to be thinking about those individuals that are more high risk, and if you can accommodate them if they want to, right? I mean, you need to let individuals, and that's a labor and employment issue, decide what they want to do. But if possible and they are willing, I think putting them in lower risk scenarios.
Yeah, so that is, there are links to those two guidances from our presentation, the one that Christy and I gave last week. There is a CDC guidance, and there is an OSHA guidance that they put out way back, I think at the end of March, that has not changed, where they categorize employees as low, medium, or high risk, depending on the kinds of jobs they have, and they make certain recommendations. Be cautious if an employee is coming to you to ask for a quote-unquote reasonable accommodation under the ADA that is COVID-19 related. You want to evaluate that in the same way that you would evaluate any other reasonable accommodation. And while it is important for morale purposes and employee-employer relationship purposes, you are not required by law as an employer to give the employee the accommodation they request. What you are required to do is engage in that interactive process and understand what their needs are, gather whatever healthcare information you might need to help you evaluate that, and then you need to balance that out upon the burden that it places on the business. And that undue burden factor has really changed in the wake of COVID-19 because many businesses have had drastic or complete drop-offs in revenues, inability to access facilities, inability to gather supplies, inventory, things like that. And so whereas prior to COVID-19, most accommodations would not be seen as an undue burden on the employer. Now many accommodations are an undue burden on the employer, so you want to be aware of that. Luke, I'm going to interrupt you because I just got, we'll get back to your questions. I just got two more.
Okay, I'm going to interject really quickly. I think the question a couple of questions ago was about the person performing antibody testing. Someone asked that, right? And whether or not they should be. So I want to keep in mind, like, these are not tests right now, and there are some that are coming, but all of the tests, I believe, that are approved right now, these aren't like at-home test kits that someone pricks a finger. These aren't test kits that you should have somebody in your workforce be providing. Does that make sense? And be the one doing these? Right now, I believe all of the 12 tests that are allowed are ones that need to be run by a laboratory. So this isn't something where, I think right now, this should not be a member of your workforce, doing the antibody testing, unless you're in, unless you work for ARUP, unless you work for, a hospital that somehow is doing these kind of tests. But in that case, it's going to be, medical professionals and laboratory professionals doing these tests, and I think they're going to be taking the precautions that they feel are necessary. So you can go on, Mikkel.
Be asking about anything that is symptom masking. And the reason for that is the only reason somebody's temperature, when you give the body temperature test, is 99.9 instead of 102 is because they've taken Advil or Tylenol or some other sort of masking medication. Then you're not really getting an accurate picture of whether or not that employee poses a risk to the company and the rest of the employee population. You are allowed under the relaxed rules that the EEOC set out in its guidance to ask if someone has been symptom-free for 3 days before they can return to work. You also can ask if someone has had a COVID-19 test and the result of that. And again, I think Christy really hit the nail on the head. That should be one of many things that you take into consideration, because a negative test for COVID-19 last month does not mean that somebody doesn't have COVID-19 this month. And it doesn't mean it might not have been a false negative. So just being really aware of that. Then another question we have is, do the CDC and WHO want to gather the anonymous antibody results that are being administered? I don't know the answer to that. I know that a lot of our local, county, and state health departments are putting in place tracing and contact tracing, so they're gathering that information, but I'm not sure what, if anything, the CDC and the WHO are doing specifically. Christy, do you know anything about that? While we're waiting for her, Luke, do you want to read us the next question?
That was all the questions that came into the chat.
Oh, so those last two that came into the chat were two of the ones you had? Okay.
Yeah, the ones that I had. There weren't any more.
Okay, well, those are all of the questions that we had for today. If you have additional questions, let me just run. Luke, can you take us to the end of the slide deck that shows our email addresses? If you have additional questions, please feel free to email myself or Christy. The slide deck will be posted. Yeah, there is a link to our bios that includes, you can get to our email, our work email there. So if you have questions that come up, please don't hesitate to reach out. As Christy and I both have stated, this information kind of changes on a dime, and so all questions are good questions, and we wish you well in navigating this. Thanks again for your participation today.